All right. Good evening, everybody. Thank you for joining us tonight for this education workshop on medical legal responsibilities in work injuries. We've got two presenters tonight. We've got Tracy Kerrigan and Dr. Zen Yap. Before we start, I'd just like to acknowledge and thank Return to Work SA for their funding to make tonight's education activity possible. We do have attendance in the room here in Adelaide, as well as those online. So I welcome our audience online as well. So before we start, I'd like to commence with an acknowledgement of country. We would like to acknowledge the Aboriginal and Torres Strait Islander people as the traditional owners of this country. We pay tribute to their physical and spiritual connection to land, waters, and community, enduring now as it has been throughout time. We pay respect to them, their culture, and to elders past, present, and emerging. Now, just a few housekeeping points. We'd like to keep tonight's education activity interactive, so please feel free to ask questions throughout the session. We do have a dedicated time at the end of the session for Q&As with our panel. For those online, please use the Q&A function in Zoom to ask your question to our presenters. There is the chat function. Please reserve that if you are having any technical difficulties. And there is an evaluation. It's on the tables for those in the room. For those online, the evaluation will automatically pop up on screen when you exit the Zoom. For RSCGP and ACRIM members, your CPD points will automatically be allocated to you within the week, so watch out for that, and statements of attendance will be sent out to everybody. Those in the room, we just do ask that you please keep your mobile phones on silent, and if you do need the back bathroom, it's just through the back door down the corridor. Now, I would like to now introduce our presenters tonight. So first up presenting, we've got Tracy Kerrigan. Tracy is a lawyer with expertise in general insurance and public liability claims and recovery claims for self-insured corporate entities. She's got a lot of experience in the areas of workers' compensation, insurance litigation, work health and safety, and dust disease litigation. Our second presenter tonight is Dr. Zen Yap. Zen is an occupational physician with experience across various industries. She works, consults at a number of different organisations at OCMED and also works in defence and is also the medical advisor for Return to Work SA. And so without any further delay, I'd like to now invite up Tracy to start the presentations tonight.
Thank you and good evening, everyone, those in the room and those online. As was indicated, I've been doing this for a long time. I'm mainly a workers' compensation lawyer acting for employers. Some of you may have from time to time received report requests from me or summonses. I apologise in advance, but it's my job. Now, hopefully tonight I'm going to give you all a bit better understanding about the Return to Work Act in particular and how we manage claims within that legislation. So the first thing I'm going to talk about is what an employer is obliged to do if they have a claim under the Return to Work Act. So if they're a registered employer, they're obviously required to notify either Employers Mutual or Gallagher Bassett of the claim within 5 business days. Employers Mutual and Gallagher Bassett manage claims on behalf of Return to Work SA. Now, I referred to a registered employer. So there are 2 types of employers within our jurisdiction. We have self-insured employers. They are basically larger employers who have been granted a licence by Return to Work SA to manage their workers' compensation claims themselves. They have to meet certain standards and requirements in order to obtain and keep a licence to manage their own claims, but basically they're managing their own risk. So those employers will receive a claim and they will take it from start to finish. And you may from time to time receive requests for reports from a self-insured employer. And we're talking about people like Coles and Woolworths, government are all self-insured, local government, they're all self-insured employers and they manage their claims themselves. For anyone else, they are registered employers and they register with Return to Work SA and they pay insurance premiums, and Return to Work SA manage the claims on their behalf and make the decisions on the claims. So the registered employer doesn't make decisions on the claim, but they have various other obligations. So their first obligation is that they must send the claim to the claims agent within 5 business days to enable the claims agent to obviously investigate it. So whether it's a claims agent or a self-insured, once a claim is received, they are required under the Act to investigate and determine the claim and make what is called an evidence-based decision. Now, sometimes it's very easy for a claim to be determined. They're required to determine them within 10 business days of receipt. If they can't determine them within that time, they are obliged to defer the claim, and it is mandatory for an offer of what we call interim payments to be made to the worker in that situation. It's an offer only. The worker can reject the offer and just maybe take sick leave or annual leave if they've got that available, or they can accept an offer of interim payments, which basically will pay them the usual wage up until the claim is determined. But the thing with interim payments is if the claim is rejected, those interim payments are potentially recoverable. So some workers, if they've got leave entitlements available, will knock that back because they don't want to take the risk that their claim gets rejected and they have to potentially repay the money. So the first step in the process is obviously this investigation and determination of the claim, determining whether it's work-related or not. And then the employer, the self-insured employer or the claims agent will then manage the return to work process. Now, it is not actually necessary for the claim to be determined for return to work to actually start. A lot of self-insured clients of mine do what they call early intervention programs. So they will get onto getting a return to work hopefully happening within a couple of days to enable the workers to get back to work as soon as possible. And we know that, you know, statistically, the sooner a person can get back to work, usually the better outcome they'll have. Sometimes with the claims agents, it can be a bit slower because they're a little bit removed from the process, but it is in fact the employer's obligation to offer suitable employment. And I've put that as one of my dot points. It's a very important obligation under the Return to Work Act. It's probably one of the most important obligations that employers have under the legislation, which is that if a worker suffers an incapacity for work, which means they can't do their usual job, and that may be that if they're totally unfit for work, they'll be entitled to income support. But if they have a partial incapacity for work, so they've got some ability to do work, even if it's not their usual job, the employer is obliged under Section 18(1) to make an offer of suitable employment. There are some caveats on that, the main one being what we call insofar as is reasonably practicable. So that's a factual issue. So your employer who's running the corner shop and only has 2 or 3 staff may find it very difficult to offer suitable employment to an injured worker because they just physically don't have work available that would be suitable, and they don't have the financial ability to so to speak, carry that worker while they recover from an injury. But a large self-insured employer, that is a different story. And generally there will be offers of suitable employment offered very quickly in order to get the workers back to work. I mean, the other issue with the return to work process is the Act actually mandates that employers have a return to work coordinator if they employ 30 or more employees. So it is a mandatory obligation to have a person on staff. Sometimes it can be outsourced, and you might find that. But otherwise, if they're large enough to have 30 or more employees, they are obliged under the legislation to employ a return to work coordinator, and that person actually undergoes training in order to manage the process of getting injured workers back to work. So the other obligation that employers have are to assist with the return to work efforts, and that obviously follows on from that obligation. And they are obliged to cooperate with rehabilitation advisors and health and other providers. In fact, the Act requires consultation with employers when they have an injured worker, and a return to work process is being put in place. So there are various standards that have to be met. So that's a quick summary of the obligations of employers under the legislation. Equally, workers have obligations under the Act. So the first one is obviously if they choose to make a claim, they're not obliged to make a claim, but if they choose to make a claim, they must give notice of the claim and or the injury as soon as possible. There are some time limits under the Act. Time limits are a bit of a moving feast in the legislation, but technically you're meant to make your claim within 6 months of the date upon which you become aware of your injury or the fact that you say you have an entitlement to make a claim. They are also obliged to provide work capacity certificates. I'm sure a lot of you know exactly what I'm talking about with work capacity certificates. So a certificate that says what their injury is, what the diagnosis is, whether they're totally unfit for work or have a partial incapacity for work. And if they've got a partial incapacity for work, if you page 2 will set out a whole heap of restrictions that might apply, and you're required to complete those certificates. So if a worker is asserting an ongoing incapacity for work, they must provide those ongoing certificates. Injured workers are also obliged to take up offers of suitable employment. So if the employer is saying to the worker and to the claims agent, or if it's a self-insurer, saying, we have work available, we say this worker could do, and we can accommodate their restrictions, the worker is obliged to take up that offer. And if they don't, that can affect their entitlement to weekly payments. So that's what we call the obligation of mutuality. So if you ever hear of a lawyer talking about this term, that the worker has breached the obligation of mutuality, usually it's that they've done something to reject an offer of suitable employment, or suitable employment's been offered to them or made available and they've refused to undertake that work. If that happens, then they can lose their weekly payments. Workers are also obliged to abide by the terms of their recovery and return to work plans. These plans must be drawn up if a worker has an incapacity that goes past 4 weeks. They usually have various terms and conditions, and they'll outline what the worker should be doing. They'll outline what the employers should be doing. They'll outline often even what the doctors might have to do in order to assist the worker to get back to work. A worker can dispute the terms of a return to work plan, but even while that dispute is ongoing, they must abide by it. And if they fail to do so, again, that can have consequences for them in terms of their weekly payments. Workers also have industrial obligations. They have an obligation to advise their employer of what they're doing and where they are. That is just a general industrial obligation. But similarly in the Act, if you are unable to go to work because you say you're in too much pain, or you've got a certificate that says you're unfit for work, you are obliged to notify your employer of that, and also obviously keep the claims agent, if your employer is a registered employer, updated as to what's happening with your condition. And again, if you fail to do so, that can have both consequences in terms of a workers' compensation claim, but it can also have industrial consequences. So these are things that workers need to understand. You can't simply just go off work and not tell anyone what you're doing. I mean, you wouldn't do it if you were sick with COVID. No different if you've got a work injury. So obviously you need to notify your employer of your absences because they need to know what's going on. And also, as an employer, you need to know who you're filling in for that day. So the next thing we're going to move to, sorry, I'm just going to find my next piece of paper. I'm very old school. I still have paper and handwritten notes. We're going to talk about compensability of claims. So the Act, the 2014 Act slightly changed the rules in terms of when an injury is or is not compensable. So we now have two tests, one for physical injuries and one for psychiatric injuries. If a worker is alleging a physical injury, the injury must arise in the course of employment, and employment is a significant contributing cause to that condition. Under the 1986 Act, all an injury had to do was arise in the course of employment. So, for example, if I was just standing here and I suddenly collapsed and I hit my head and I hurt my head, that would have been a compensable injury because I was at work when I did it, and that's all I needed to establish. The 2014 Act changed that. So now I would have to establish not only that I fell and hurt my head, but that the reason I fell was as a result of my employment, not because I just happened to be clumsy or that maybe I was sick and I fainted. I've had plenty of those claims, frankly, where people have fainted at work and hurt their head. Under the 86 Act, that was compensable. Under the 2014 Act, they have to establish why they fainted, and that employment is, in fact, a significant contributing cause of that condition. So it's a combined test. So that was a change from the 1986 legislation. So with our psychiatric injuries, they have the same test, but employment must be the significant contributing cause. And there is a difference, not a huge difference, but there is a difference. Having said that, it doesn't have to be the only cause. And the other issue that you need to be aware of with psychiatric injuries, which I can say are the most difficult and complex claims we deal with, is that there are certain actions by an employer that will what we call disqualify the claim. So, for example, if the employer gave a worker a notice saying, we're investigating your behaviour at work, there's been allegations made against you, they send the worker a notice, we want you to come to a meeting, we want to discuss these allegations with you, and immediately the worker goes off and gets a certificate and says, I'm unwell, I'm suffering a psychiatric injury as a result of that. As long as the employer has acted reasonably, then that claim might be disqualified because it arose from those actions of the employer to manage their employee. So not everything that happens at work is something that will get them over the line, particularly with psychiatric injuries, because as I said, they are usually the most difficult claims that we deal with. So I'm now going to talk about this issue of significant contributing cause, because as I said, with the 2014 Act, that changed the landscape slightly, and we had a lot of case law about what did that actually mean in terms of employment. And I think it's helpful for GPs to understand this because it might explain to them sometimes why their patients' claims might get rejected, even though they think that it's quite clear it's work-related. So, as I said, for both physical and psychiatric injuries, employment has to be, for a physical injury, a significant contributing cause, and for psychiatric, the significant contributing cause. Basically, following a whole series of cases, what the tribunal and the full Supreme Court came up with is that significant is generally the substantial or most influential of all the causes. So you can have more than one cause contributing. So I guess with my example of I fainted at work, I happened to have the flu, but I was also happened to work 12 hours straight in a hot environment, and that caused me to become dehydrated. And as a result, I fainted. So potentially that might be a significant contributing cause. The Roberts case was, I think it's Roberts, I'm pretty sure it's Roberts. Case was a very interesting factual case. A lady who was a hairdresser was working in the far north, teaching, I think, Indigenous students. She was in less than salubrious accommodation in a caravan park. It was extremely hot. There was no real air conditioning in the unit that she was staying in. And as a result, she had to keep the windows open. She said she was bitten by mosquitoes and as a result suffered an inflammatory arthritic condition as a result. So a pretty unusual fact situation. But after hearing all of the evidence, the judge was satisfied that employment was a significant contributing cause of her developing the inflammatory arthritic condition. So basically what they were saying is that there has to be some sufficiency or connection between the worker's employment and the injury that enables the judge to come to the conclusion that employment is a significant contributing cause. Now, I've already talked about psychiatric injuries and how they are the most difficult ones we deal with. Again, the work condition or injury doesn't have to be the only cause. It must just be the significant contributing cause, so the most influential. In the case that I've quoted, Van Hattem, which was the first case that dealt with this, the injured worker had significant prior psychiatric history, a lot of difficult family issues at home. She was a teacher, but there were incidents at work that clearly caused her condition to seriously deteriorate. And after hearing all of the evidence, the judge was satisfied that despite all of the outside factors and the pre-existing psychiatric history, employment was still the significant contributing cause of her suffering a major depressive injury. A lot of people seem to think that you have to have no prior psychiatric history in order to get a claim up. That is quite wrong. The Act does envisage aggravations and exacerbations of pre-existing conditions, both in terms of physical and psychiatric injuries. What is necessary is to show and establish that employment has caused that aggravation or has been the significant contributing cause to it. And then I've raised again the issue of these disqualifying factors, and a lot of them relate to employment management issues. So disciplinary processes, counselling, terminations of employment. A lot of people seem to think that the only way psychiatric injuries get up is if someone's bullied and harassed. There's actually no reference to bullying or harassment in the legislation. There's also no reference to workload. There's no such thing as a reasonable or unreasonable workload. Those are not necessarily disqualifying factors. So generally what happens with those sorts of claims is there's a detailed factual investigation and usually a detailed medical investigation. And as GPs, you might be asked to provide a report or your medical notes, particularly if there have been prior events or complaints by a worker of events that have occurred at work that may have been causing them to suffer a psychiatric issue. So the first thing you're probably going to have to do as a treating general practitioner is you'll be asked to complete a work capacity certificate. And we talked about that at the beginning, and it's really an essential part of any claim submitted by a worker. It enables decisions to be made by the compensating authority, both in terms of determining a claim and also managing a claim and enabling a return to work to occur. So a WCC, as I call them, is a very important part of the process, and we do rely heavily upon them. And trust me, I review them regularly. I'm always like, what's the diagnosis? What's been added? You know, what is the level of incapacity? So it is a very important document. So in terms of what GPs need to do is really to ensure that all parts of the document are completed. But of course, that must be based on the history that your patient gives to you, their symptoms, their complaints, your diagnosis. You might be asked to indicate who you've referred the worker to, whether it's physiotherapy or a specialist for further investigation. So really often the restrictions that you put on the page 2, both in terms of capacity and incapacity, are very important because they will assist the return to work coordinator or the rehabilitation advisor in structuring appropriate efforts to return that injured worker back to work. We always want to know what the injury or injuries are that are initially complained of, particularly when we get claims that might be submitted some months after the event, which does happen quite regularly. People don't necessarily make a claim straight away for various reasons. The other aspect that's very important is whether there's a change of diagnosis over time, possibly because further investigations have occurred, and you've had maybe an opinion back from a specialist as to what the problem is, and then obviously how is that related to the worker's employment or their original injury. I mean, are they complaining of new or different symptoms? And again, how does that relate? So these certificates are very important, and we look at them a lot. The other thing that you'll be asked to consider is there some type of work that can be performed despite the fact that your patient has an injury? And often you will be asked to liaise with either the self-insured employer or the claims agent or a rehabilitation advisor who's been employed to assist the return to work process. Please don't make assumptions about an employer and their business. I've often seen certificates provided that say this person's totally unfit for work. And then when you drill down, it's because the doctor just said, oh, well, I don't know anything about that workplace. I just know what the worker told me, and he told me it's heavy. Well, what does that mean? So, you know, I think it's a poor assumption to make that no work can be provided. So I think it's important to understand that employers have an obligation to offer suitable employment, and generally most employers want to get their workers back to work. They, you know, it's costly not to have people at work, so they really will hopefully be making that effort. I mean, I'm generalizing here, but most of the employers I deal with, they want to get people back to work because they see it as good for their business. It's also important, as I said, to indicate what other providers you're referring a worker to, as again, that can assist with both the claims management and the return to work process. And also it can help because sometimes it can help get early treatment and referrals. And again, that helps the return to work process. This is probably the bit that none of you like, getting a request for a medical report. And I understand that it can be frustrating, particularly because often you'll get what I call quite standard requests. They're the same report requests, just with a different date. And one of the standard questions asked, is the injury consistent with the stated cause? What I would like you to consider is, what do you know the stated cause to be? What has the worker actually told you? And instead of hopefully just saying yes, and I've seen that, like yes, okay, well, what were you actually told and what was the stated cause? So was the stated cause the fact that the person was lifting a pallet of product or breaking apart a pallet of product? Or was the stated cause because they tripped over something, or was it something else? So what was told to you as the stated cause? And then it would be preferable if you could put that in your report, because that is actually important information. Always consider the questions carefully and endeavour to respond as fully as you can. I understand that everyone, you know, is very busy, and I'm sure you've all got lots and lots of patience, but it is very helpful for your patient if there is a carefully worded response, because that will assist with the claim determination and hopefully a return to work process. You will usually get questions about capacity for work. Again, this is one of the most important issues that you'll be asked about. Because, as I said, most employers are trying to get people back to work as soon as they can. And it's always preferable if you can consider what an injured worker can do rather than what they can't do. And if you're not clear on what type of duties might be available because you've never dealt with that business before and you don't know anything about it, usually there are people available who can assist you to get that information, and that might be by way of a case conference with a claim specialist or a return to work provider or the employer themselves. Or it might be having a discussion with the employer if you're authorised to do so. Obviously, if you're unsure of a diagnosis, then You may refer your patient to a specialist, and in that situation, I suspect that the compensating authority will also write to that specialist. But generally, often the first port of call for most of my clients is to seek a report from the treating GP as the first step in a claim determination. And it's okay to not be sure. We all know that medical issues are difficult and complex, and not everyone has the answers. And it's okay to say, I don't know. I don't know the answer to your question. The other thing I'd say is don't be an advocate. It detracts from your position as an expert. All of you are experts, and you're being asked to provide an opinion as an expert. I have seen reports where doctors have unfortunately made comments that are derogatory about the compensating authority or the employer. That doesn't help your patient, it doesn't help their cause, and it certainly doesn't help your position if you were to have to give evidence at a later date about it. So maintain your independence and don't be an advocate for your client. There are plenty of lawyers and union people out there who will advocate for them. So your job hopefully is to get them better and help them along that path. Now, in order for you to provide any information, obviously, sorry, I've gone too far. You must be provided with a medical authority signed by your patient. You can as a result of that, you can disclose the relevant information in terms of the treatment and the history provided to you and any other relevant information that will assist in responding to the questions that you're being asked. You may be asked to disclose clinical notes regarding a specific injury or more generally. Now, a lot of doctors seem very reluctant to provide clinical notes, and I understand that there can be some reluctance, and some doctors will only provide them pursuant to a summons, but you can only get a summons if you're actually in dispute. So often the request for clinical notes is really to try and investigate the claim. So you're not actually in dispute. And we don't ask for clinical notes just on every file. I mean, they are sought for a reason, usually because there's some issue about the history or the onset, or it's a claim that's been made much later than the date of injury. There's usually a reason for clinical notes to be requested. So, like I said, they're not asked on every claim, and we don't need them on the straightforward claims. They're usually the more difficult claims. So if you get a request for clinical notes, please hopefully consider it favourably, but I know that some practices have policies about that. You are more likely to get a request for clinical notes in psychiatric injury claims. Again, because they are so complicated, and often people don't often react simply to one event or one incident. Usually these problems arise over a period of time, and there may be several events at work and outside of work that may all contribute to a person suffering a psychiatric illness. So that's often why clinical notes are requested in order to assess what's happened over time and what are the major factors that have contributed to the person suffering from that condition, and is it related to employment? So what is the significant contributing cause? So it's really part of the investigation process, because generally it's not like suffering a sprained ankle. Generally, these things potentially build up over time, and there are a lot of issues that can occur that eventually result in a person going off work. If you're asked to provide notes, it's often possibly because the worker's had prior injuries, and that will be relevant to determining the current claim. The worker might be saying, oh, I've aggravated a prior injury, and you've got medical information that's relevant to that. And often it's because they haven't reported the injury, and you're trying to backtrack and find out, when did they first go to the doctor? What did they tell the doctor was the cause or causes of the condition, and what has occurred over time? having a pre-existing condition does not disqualify a person from making a claim or having a compensable injury. But it is important to understand the history that's gone on before in some claims. If you're asked to provide a medical report, then always respond to the specific questions. And I understand that sometimes the questions are very standard. I try not to provide standard report requests, try and tailor them to the actual claim that's being made. But, you know, busy claims officers who are managing hundreds of injury claims don't necessarily have the luxury of that. So the main issues are usually diagnosis and causation, work capacity and ability to return to work on suitable duties, and obviously treatment needs. Particularly now with the legislation, because there is a time limit on entitlement periods. So unlike the 1986 Act, the 2014 Act has some strict time limits on which people can get their entitlement. So if they're having treatment or needing treatment and they want it paid for under the work cover claim, it's got to be within that time frame, unless the person is seriously injured, and that's a different issue again. You might also be asked to provide diagnostic imaging or other test results, which will be relevant to the determination of the claim. So again, coming back to medical reports, they can be requested for a variety of reasons, but usually the first reason is claim determination and investigation, and establishing that causal connection to employment and establishing capacity for work and ability to return to work. They will also establish treatment needs and if further investigations might be required. As the claim proceeds, you might be asked to provide an update report. Generally, it's usually if there's issues about changes in capacity, other symptoms coming forward that weren't previously complained about, delays in return to work, issues being experienced. You might also be asked to comment on the views of an independent doctor who might have expressed views that are different to yours. The other aspect you might be asked about, this will usually be sometime into the claim. It won't be initially, but you may be asked to certify whether or not the worker has reached maximum medical improvement. The purpose of that is to enable the worker to be assessed as to whether or not he's suffered a permanent impairment, and that enables the permanent impairment assessment process to commence. So that's the first step in the process. But that will generally be some months down the track, depending upon the injury, whether the worker's had surgery, how they've recovered, and whether or not the condition is an ongoing one. You will not be, as a GP, asked to assess permanent impairment itself. That is restricted to accredited assessors. That's how the system works. Perhaps in the past you may have been asked to comment upon that, but that no longer applies. I've put there some report writing tips. Obviously, making sure you've got your medical authority, being timely. Some of the biggest problems that we experience is waiting for reports to come in, because obviously that potentially delays claim determination. Always read and refer to your records. Try and avoid abbreviations. You're writing to people who are not doctors. I got a report once that kept referring to NIDDM, and I'm not a doctor. Eventually, I actually rang my brother, who is a doctor, and what's this abbreviation? Non-insulin diabetes mellitus. I'm like, okay, well, now I know what that is. So that made sense. All the doctor had to say was the worker was diabetic, and I would have understood what they meant. Avoid legal terms. What you may understand the legal term to be and what the legal term might actually be could be two different things. Try and include all the information that you consider to be relevant, and avoid emotive language. Again, it affects your status as an independent expert. Keep within your medical knowledge. And if something's outside of your medical knowledge because it's a condition you don't deal with, or you're obviously not a specialist, very easy to say so. And answer the questions. I see many reports, unfortunately, where the question is not actually answered. and you end up having to go back and try and clarify that with the doctor. And obviously the issue about maximum medical improvement and whether or not a worker is medically stable. They can actually be two different things legally. Now, we do, as compensating authorities, arrange independent medical examinations, not on every file. There are some files that never have an IME. Generally, they're used for a specific purpose. Often, if there's a lack of clarity from either a treating specialist or a GP about the diagnosis or causation or capacity or treatment needs, or if there's a lack of response from a treating doctor. Now, this often happens that the treating doctors don't respond, or they might be reluctant to actually provide an opinion on causation. And Zen and I were talking about that before we started, about doctors not wanting to necessarily comment on causation because they don't want to impact on their relationship with the patient. And I accept that. But as a result, you might find that your patient is asked to attend an independent medical examination. Can be usually done if the condition is unusual or not something that you would normally think is work-related, and requires a specialist opinion. It might also be arranged if there's apparently a lack of progress or improvement within what might be considered usual timeframes for recovery, or where a second opinion is needed. And I know Sen does quite a bit of second opinion medicine. Generally, the IMEs are specialists in a relevant field. So it might be an orthopedic surgeon for a fractured leg, or an occupational physician, particularly if it's an issue about capacity or impairment or suitability of alternative work, because obviously they have a better understanding about workplaces and suitable work duties for particular industries. Psychiatric claims, you will generally find there will always be an independent medical examination with a psychiatrist, mainly to ensure that the DSM-5 diagnosis is established, to examine the cause or causes in details. That can be quite a forensic exercise, and also to comply with those technical requirements in section 7, 3 and 4 of the Act. So they're the provisions that say psychiatric injury must be the significant contributing cause. And also section 7.4 are those disqualifying factors that I talked about, actions by the employer to manage their employee within the workplace. Often the IME will be asked to comment on those issues. So most psychiatric claims would normally have an IME. Now, I've talked about maximum medical improvement. This is an issue that you will often be asked about, usually a little way down the track in the claim, not initially. It is for the specific purpose of enabling your patient to be assessed for any permanent impairment that they may have suffered as a result of their work injury. To commence the process under Section 22 of the Act, there must be a certification of MMI. It's an important question both for you as the GP, but also the accredited assessors also have to independently come to that conclusion when they see the worker. But generally, the process won't even start until the treating doctor has provided certification of MMI. MMI has been interpreted as the condition or state that is well stabilised and unlikely to change substantially in the next year, or 6 to 12 months, with or without medical treatment. There can still be change over time and can be some fluctuations, but generally it's anticipated that there will be no further recovery or significant further deterioration. It can be difficult with some conditions to actually achieve MMI. So it is sometimes can be a difficult concept. And as GPs, I'm sure you're often asked if MMI has been achieved, but you won't be asked to assess the actual impairment because that is restricted to the accredited assessors who are accredited by Return to Work SA to undertake these assessments. What is impairment under the Act? It is as set out in AMA 5 definition. It's the general concept of impairment. So it's a loss of use or derangement of any body part, organ system or organ function. There must be an anatomic loss or a functional loss. Pain is not an impairment. There has to be some sort of physical impairment. As I've indicated, under the South Australian scheme, we use the 5th edition of the AMA guides to the evaluation of permanent impairment, but these are modified by Return to Work SA's impairment assessment guidelines. Those guidelines are currently under review. We did have a 2nd edition for a while, but that has now been thrown out and we're back to the initial guides, but the legislation is currently being reviewed and these guides are under review. So it is anticipated there will be a 3rd edition of the guidelines, which will then modify the AMA guides. Each body part or section has its own methodology. So the way a knee gets assessed can be different to the way a back gets assessed, different to the way a neck gets assessed. There are diagnosis and disease severity ratings. So there's usually a class that a person falls into. There are specific percentages for someone who unfortunately suffers an amputation. If the injury involves grip strengths or range of motion, that will also be taken into account. And this is why the assessors are accredited. So not everyone's accredited in every body part. So you can have one doctor who's specifically accredited to only do the spine or to do upper limb or lower limb, and other doctors who are specifically accredited to do hearing loss and nothing else, obviously ENTs. So generally the assessments are done by specialists in the field. So it's quite a tricky and complex process, and the details are governed by a lot of fine print. For psychiatric injuries, we don't often do impairment assessments. The reason for that is that psychological injuries do not attract lump sum compensation. The only reason for doing an assessment of permanent impairment for a person who's suffering a psychiatric injury is if that worker is claiming that they are seriously injured. To be seriously injured for a psychiatric injury, you have to achieve a whole person impairment of 30%, and that is assessed under what we call the GEPIC, which is the Victorian publication for the Guide to the Evaluation of Psychiatric Injury Claims. So there's not a lot of psychiatric assessments generally because most people will not achieve 30%. Now for a physical injury, you have to achieve a 35% whole person impairment. It used to be 30%, but it was increased in the most recent amendments about 12 months ago. A seriously injured worker will get more than the usual 2 years of weekly payments. They will get weekly payments until they reach retirement age. So they've got a significant injury. So I'm now going to talk about, and I think I'm almost to the end, so we're moving along relatively quickly, which I'm sure you'll all be very happy about. Listening to a lawyer for more than half an hour, it's probably killing you all. The last thing that I'm basically going to talk about is the dispute resolution process. And hopefully for all of you, you never have to go there, but sometimes you will have involvement. If a worker is dissatisfied with any decision that is made on their claim, for example, that could be the initial determination. It could be their entitlements being discontinued. It could be their entitlement to a lump sum. It could be a rejection of some medical accounts. They are entitled to file an application for review at the South Australian Employment Tribunal. Employers are also entitled to dispute decisions. And generally, in my experience, I mean, self-insurers are not going to dispute their own decision. This is registered employers, but registered employers will generally dispute only the acceptance of a claim that they genuinely believe should not have been accepted. But it is possible for an employer to file a dispute. But generally the disputes are going to be filed by a worker who's dissatisfied. The application has to be filed within 28 days. You can get an extension of time. It goes through what we call an initial reconsideration process. So someone other than the person who made the decision must review the file and the decision that was made, and they can either confirm the decision, which means it then goes into a compulsory conciliation process. Excuse me while I cough. Or they could vary the decision in some way. For example, an average weekly earnings dispute can often be varied during reconsideration to change the rate. So I'm just going to grab some water because I've got to. Sorry for everyone online. I'm just going to have a quick water. If we assume that the decision that was made is actually confirmed, as I've said, it will be referred for compulsory conciliation. A commissioner presides over that process. Commissioners cannot make actual decisions. All they can do is assist the parties to come to a conciliated outcome, whatever that might look like. An employer has a right to be involved in that process as well. So I often get involved in three-way disputes at the tribunal where you have the worker who's dissatisfied with the decision, the claims agent who's made the decision, and an employer who wants to be involved to ensure that their interests are protected. And often that's because there might be industrial issues with that particular worker. If the matter doesn't resolve during that process, which is meant to take about 13 weeks maximum, but can drag on a bit longer, unfortunately, usually because we're waiting on relevant medical reports or other information to come to hand. But if it doesn't resolve, then the commissioner has no option but to refer the matter to hearing and determination before a judge of the tribunal. So basically, you're referred to trial. And that can take quite some months to go through the pre-trial processes, which can involve the parties filing affidavits of evidence, statements of issues in contention. We can have legal arguments. We can also have settlement conferences before a judge. And frankly, as I said to Zen, 99.9% of all cases actually don't go to trial. They actually settle. They may not settle at conciliation, but generally somewhere through the process, the matter will settle. So only a very small handful of matters actually proceed to trial with a judgment being handed down. I've actually got a matter resuming next week. I reckon it's the first case I've had go to trial for about 18 months. So we don't actually have a lot of matters go to trial because the parties will try to resolve matters if they can, because if you go to trial, then the outcome is out of your hands. But if you can come to an agreement, whatever that agreement looks like, then you've got some control over the process. If a party is not satisfied with the judgment, they can appeal to the full bench, but only on questions of law, not on questions of fact. And there is an ultimate appeal to the Court of Appeal, which is the Supreme Court. But again, questions of law only, and the Supreme Court has to grant leave. You may sometimes be booked to give evidence. That will occur if you've provided a medical report and the opposing barrister wants to cross-examine you. Otherwise, if there's no need to cross-examine you because your evidence is going to be uncontroversial, then your report can simply be tendered without the need for the doctor to actually give evidence. But if the opposing barrister wants to cross-examine the doctor, then they are required to be called. If they don't, then the report cannot be accepted into evidence. So if you get asked to be booked for a trial, it's because at the moment the opposition wants to cross-examine you on your report, because the report can't go in any other way unless it's by agreement. So, you know, if you get asked to give evidence or asked to be booked for evidence, that would be the reason why. But as I said, most cases will settle, hopefully not on the doorstep, but that still does happen, unfortunately. All right, I think that's it from me. And I'm going to, are we doing questions now? Sorry, I've forgotten what we decided, unless there are none.
There is one question that's come through online, in case
Sure.
anyone has anything in the room, and I can read out the question online. It's from Joshua Daly. If unsure and deferring to a physio to assess capacity and limitations, what does one do? What does one then put on the capacity to return to work and timeframes?
So I take it that the question is, if the doctor's not sure about what the capacity restrictions are and has deferred to a physio, what should they put on the certificate? Well, I would hope they would confer with the physio and what the physio has suggested on the certificate. But I guess if they haven't, then you would probably refer to physio. Like, I guess you're passing the buck in that situation, but presumably if there's some conference or conferring between the physio and the doctor, there's some report back. Would you agree with that, Zen? Or perhaps I'll hand over to Zen on that one.
I guess my take is that if a GP is not too confident in certifying and the physio has done an objective assessment, I would then consider that, I think it's appropriate, as long as there's evidence behind that certification, to put it on the work capacity certificate, and then maybe just put as per physio assessment or something like that. That would be that would be what I'd put on the work capacity certificate.
Yeah, that actually sounds right to me, because actually physios can't provide certificates. We only allow work capacity certificates from legally qualified medical practitioners, and in some circumstances now nurse practitioners in hospitals, but that's generally only right at the beginning of the claim. So, but if the physio has conferred with the doctor and provided the information, I see no reason why the doctor can't then write that on the certificate.
Now, Joshua's come back with some further information. So this is a time issue. It doesn't happen in real time. A physio will see the patient at some point in the future. But today, what am I saying?
Well, I think, and Zen will correct me if I'm wrong here, that if the doctor doesn't know what the restrictions are or what the capacity is, then I guess they have to say, I don't put anything. I mean, are they certifying partial capacity? They believe the worker has some capacity for work. They're just not sure what it is. I mean, the certificate, if you look at page 2 of the certificate, has a whole heap of boxes where you can tick, body part and can or can't. Yeah. So that's something I think the doctor should still be able to do, even without knowing what the physio says about, say, return to work, for example.
I think the certification can be quite generalized and can be quite specific at the same time. So if you're not really sure, I'd probably go generalized. So, you don't have to put an exact figure to the heavy lifting, but a rough guide, say 5 to 10 kilograms, could be generally what you'd go by if it's depending on the severity of the symptoms. But other stuff like, avoiding repetitive heavy lifting or a sustained posture, simple generalized terms like that might help. I think the certification tends to be a little bit of a guessing game, to be really honest with you. There's no hard and fast rule about how to do it. So it comes with a bit of experience, but at the same time, I think just using common sense in the first instance would probably be the way to go.
Yeah, I totally agree with that.
Perfect. Thank you. We don't have anything for anyone online. Does anyone in the room have any questions, or those online, feel free to type any further burning questions for Tracy. Otherwise, there is an opportunity at the end when we have both speakers. No? All right. I'll hand over to Zen.
Thanks. So I think Tracy's pretty much covered most of the medical legal stuff. So what I'll be doing today is just talking from a medical aspect, okay? So I think good medicine ultimately is good medical legal practice, because at the end of the day, as long as you do your job as a GP, do the full history, clinical examination, and then obviously document. That's all you really need to do. So from a GP's role and responsibility, it's essentially the same. Like I said, history, clinical examination, make your diagnosis. And then the only difference, I think, between this, a work injury and other sort of injuries is the certification, the work capacity certificate. Now, I think when it comes to the diagnosis, as Tracy said, it's not necessary that we know the diagnosis, especially not on that first visit. So I think it's definitely okay to put something such as, cervical pain or knee pain for further investigation. And then that can be generally altered each time you see patients. So when you get further information or have a more clear diagnosis, that can be changed. And I think the big thing with workers' comp is really document, because, if some dispute arises 6 months down the track or any queries around the history that happened in that first instance, your initial appointment's really, really crucial. So clinical history. I've put in here the Bill Glass triangle. So I use that quite regularly in terms of causation for work injuries. Bill Glass was basically the godfather of medicine in New Zealand. He, I think, helped with creating the asbestos register. So in here, I'm not sure if you can see the mouse. So the top one is really around the work side of things. So how does a worker do his specific duty? Are there any hazards in the workplace that can actually contribute to the causation of the injury? And the work itself, is it long work hours? Is it a specific workload? Are there no breaks? Is it repetitive? That kind of thing. And then obviously there's the worker as an individual. Are there stuff at home that is contributing to the injury? Is it his individual risk factors, his genetic risk factors, any, constitutional symptoms? And does he do any activities outside of work, any high risk recreational activities? One big thing that I think we need to take is also the occupational history when it comes to workers' comp. So what do they do for work? Do they have one job, two jobs? And do they do shift work? I think the fly in, fly out workers do come with a specific set of difficulties as well, because a lot of employers who do the fly in, fly out need them to be of a certain capacity before they actually fly them out back on site because of limitations of modified duties. And then, duration of employment. I think that's also quite important. If someone has just started work, they're not accustomed to the kind of workload that is required of the job. Does that then contribute to the causation of the injury? And industrial issues, it can actually contribute to how the rehab progresses or how they recover from an injury. And who's the employer, the type of employment, is it casual or permanent? Because I guess with casual work, that doesn't entitle them to leave entitlements, so annual leave or sick leave, compared to those who are under permanent contract. And then, as everyone wants to know, the mechanism of injury. So the claims managers will ask you this, and in your medical report, that's probably one of the big things about determining a claim: how, when, and where it happened, and how it actually came about, whether it's an insidious onset or whether it's a more sudden acute onset. So going on to clinical history again, it's the psychosocial history, because as we know, yellow flags really impact the recovery of some individuals, or rather all individuals, sorry. Whether they have activities outside work, their hobbies, smoking, alcohol, drugs. And again, past medical history, because that actually helps determine whether you think it's an aggravation injury or whether it's, something that has been going on for quite some time and isn't a new thing. And then as with function, figuring out their current symptoms, what the current activity levels are, not just at home, but also at work, actually allows you to put pen to paper and write down what you think is their capacity on that work capacity certificate. Physical examination. I know everyone's really time pressed and it's quite not often done. And it's quite easy to just do a clinical history and then refer them off. But I think it's really important, especially in diagnoses such as subacromial bursitis, where, you know, you find these radiology findings in pretty much everyone, even the asymptomatic individuals. So doing that clinical examination will actually help you determine whether the subacromial bursitis you find on radiology is actually, you know, is an actual diagnosis of symptomatic significance. Yes, and you'll also definitely be asked that in the medical report. So it's really important to actually communicate. When it comes to workers' comp claims, there are quite a few stakeholders and everyone wants ultimately the same outcome, but everyone is not usually kept in the loop. And that's when issues start to arise. So, you know, using the codes for phone calls, case conference, and third-party consults, they're all funded by Return to Work SA. And we probably encourage you to actually use them because communication actually drives better outcomes. Now, so case study. So we have Tom, a 58-year-old warehouse worker. He's developed gradual onset of worsening lower back pain. So what do? History. Basically take a full history, again, using the Bill Glass triangle, figuring out, you know, when did it actually happen, where, how, and as discussed earlier, all the past medical history, full occupational history, you know, in terms of his work, what kind of work does he do? Does he have a part-time job, full-time job? What actually brought about the actual injury? In workers' comp claims, you'll hear the claims managers frequently talk about flags. So we all know about the red flags, the things that have significance in the medical history. So, you know, for example, cauda equina, have they lost control of their bowels? Those kind of things are red flags. But orange flags would be the psychiatric symptoms. Yellow flags, which is frequently brought up, are the psychosocial factors. You know, do they have fear avoidance? Do they have an adverse reaction to certain things? What are their beliefs? What are their expectations? And yeah, like I said, pain behavior. Blue flags are their perceptions about the relationship between work and health. And black flags are systemic things that can actually contribute to how long or a protracted sort of recovery. So this is a study. So It Pays to Care is an initiative that was done by RACP and AFOM, which is the Australasian Faculty of Occupational and Environmental Medicine. So they found that there is strong correlation between having a positive claim experience and a good return to work outcome. So when you show that you care essentially to a patient, and you show that genuine attitude of having that same aligned goals of having them return to work or getting their life back at the end of the day, that has shown that you will get better outcomes when, I guess, you do care. Now, in the document, it actually highlights the importance of non-stressful interactions with healthcare providers and the importance of being appropriately positive. And I'm not saying, you know, give them false hope, but really just be careful about the language that we use, you know. Don't typically, so for example, disc bulges. Disc bulges are commonly found in most, well, 20% of 20-year-olds and 80% of 80-year-olds, but that doesn't necessarily mean that it's the cause of their back pain. So having the language and trying to avoid words like wear and tear or, you know, things that have negative connotations actually makes a difference in how they perceive their condition or their illness. Now, it's also really important to ascertain and set the clear expectations from the word goal. Having that goal setting expectation discussion at that first few visits will actually help them sort of envision how their progress or their recovery is going to look like. And then there won't be mismatched expectation and reality. So as Tracy was talking about the work capacity certificate, I've highlighted here a few key things that we really look at, especially when it comes to, say, independent examination, so IME. The first one up the top here is the date of injury. That makes a big difference, especially in determining their length of claim, because with the 2014 Return to Work Act, it gives them only that 2 + 1 year sort of time frame. So at most 3 years of medical expenses. And generally that date of injury is used to determine when the start date is. Stated cause. Try to avoid just putting work as a stated cause because that doesn't give us enough information. So I've been asked to do quite a few IMEs when there's insufficient evidence on the work capacity certificate because work seems very big. It doesn't actually give them any detail and no backing behind why it should really become a work cover claim. So ensure you put lots, as the more information you put on the work capacity certificate, I think the better. And again, like I've mentioned earlier, the diagnosis that can be gradually changed as we know more or if we find more evidence to support different diagnoses. And you can add to that as well. And this is the second page, right? On the top, you have physical function. So you can put can with modifications or cannot. And please put details on the side of it where they have section for comments because the more you put, I think the better it is both to help the employer, but also the insurer because it allows them to sort of provide suitable duties. Even if you're not sure of what exactly to provide, that those tick boxes gets you thinking about, can they sit for prolonged periods? Should I put a time frame or a cap, sit for a maximum of 1 hour before they get up to stretch, etc. Can they walk, stand? Are they allowed to do low level work? Whether they can kneel or squat. Carrying, holding, lifting. I know sometimes, like Josh mentioned, it's hard to actually put an exact figure to the amount of lifting that they can do. But I think a vague estimate or a vague guide. So light lifting would be anything below 5 kilos to 7 kilos. Any medium sort of lifting would be, somewhere between 10 to 15 kilos. But generally, all workplaces are restricted to a maximum of a 25 kilo lift anyway. So I wouldn't be expecting anyone to do more than 20, 25 kilos lifting in the ideal way. So this prescription of capacity not only applies to things at work, but it also applies to life outside of work. So just because they're restricted at work to lifting doesn't mean that they can go lift things outside of work. So I just be careful about the certification in that aspect because some people have been caught out. Now, as Tracy mentioned, with the duties, if you're not really sure what your patient or your worker actually does, just picking up the phone if you have time actually really makes the biggest difference because there will be employer representatives, whether or not it's, a supervisor or a return to work coordinator, they're more than happy generally to pick up that call if it means that it makes a difference between you certifying them unfit and fit for modified duties. And sometimes if they are impossible to get in touch with, the claims manager would be a great in-between contact person. The other thing, I wanted to highlight as well is under the functional capacity or functional considerations, there's a section about the medications that you prescribe. So a lot of opioids or stronger pain relief have the sedative effect. So if you prescribe anything with risk of sedation, it's probably worthwhile to put it in there, especially if, part of your role is, say, driving commercial vehicles or just being around a really dangerous sort of work environment, working at heights, etc. That really makes a big difference into their capacity. So now, Tom has now had 1 week of work. What should we do? Now, early intervention has been shown. So these figures here are the amount of workers that get back to work in the first 4 weeks, in 13 weeks, and in 26 weeks, as well as 52 weeks. So generally, at the 10-week mark, only 1/3 of patients ever return to work. And that's just on modified duties. It doesn't necessarily mean that they return to pre-injury duties. 1/3 of people actually ever go back to work. So, the other two-thirds of the individuals who are not back at work at this stage never return to work. And that's actually quite a terrible statistic. So if you've had more time off work, your chance of returning actually decreases. So at 20 days, 70% chance of ever returning to work, but at 70 days, only 1/3 will ever return to work. And this is a 2022 data, but it hasn't changed in 2023 financial year. And this here, I think it's in comparison to the one before. So 4 weeks, pretty similar sort of statistics, 83.2, and then at 13 weeks, 91.9, and at 103 weeks, which is roughly the 2-year mark, 95.8. So if you see after that 13-week return to work timeframe, the increase is quite marginal as you go up, or as time increases rather. The health benefits of good work. This is an actual statement that's brought out by AFOM, the Faculty of Occupational and Environmental Medicine. It states that the longer someone is off work, the less chance they have of ever returning, and that's supported by data. The most common health conditions ultimately will not be cured by treatment. So really having that good work as part of your therapeutic interventions or your recovery or your rehab is actually quite vital to their well-being. So typically waiting for recovery actually delays recovery. So if you set them up with longer time frames for recovery, so if you give them more time off, it actually delays their recovery rather than actually helps their recovery based on statistics. Staying away from work will actually lead to other sort of issues, the depression, isolation, and poor health outcome. Employer-supported early return to work actually helps recovery and prevent deconditioning. So this actually has been supported by evidence, not just in that study I've just mentioned, the health benefits of good work, but it's also been in the It Pays to Care document. So now you've given him 4 weeks of work, but his back pain is not actually fully recovered. So the case manager is growing concerned, employees getting frustrated, and the GP has not responded to the report request from the eligibility officer. So the eligibility officer is the one who actually determines whether the claim's accepted or not. And so the claims manager, or the eligibility officer rather, refers them for an IME. IMEs can actually be quite a stressful process because they are fronting up to a doctor they don't know. It's actually from patient experience and from patient feedback, no one actually really likes going for an IME. And trying to avoid this as much as possible is probably in your patient's best interest. I think when you find out that they're being sent for an IME, it's also important not to guess what the IME is going to say, because more often than not, you'll probably get it wrong. And reinforcing that it's actually just part of the process and they're not being targeted or, they're not being basically targeted, and they're not the only ones actually having to go through an IME is really important. So communication. As long as you've got the worker's consent, ensure that they're probably in the loop all the way through. I think having them be in control, having them not have an external locus of control is actually beneficial to their mental well-being and as well as their recovery. So having case conferences are really, in my opinion, are really very beneficial because you've got everyone who's actually part of the treating team on the same page. Having everyone in the same room discussing everything that needs to be discussed with the worker present is great, I think. So if you really struggle, there are medical advisors, and you can reach us by either dialing the number or actually sending an email. So this line and email address are actually managed by Return to Work SA. But if there's a medical question that needs to be answered, we generally get their contact details. So GP's contact details. I frequently call GPs to actually discuss individual cases if required, and to sort of help direct. But there's also the SOM pathway, that is the second opinion medicine pathway. We've got leaflets at the back as well, just giving you a brief outline on how it actually works. All specialties, neurologists, psychiatrists, occupational physicians. So you basically get seen within 10 business days, but you get seen once. And then you're not allowed to be seen by that same practitioner for the next 3 months. But in that comes the fact that the specialist will actually give you a ring, will talk to you about the case after the consult. And you'll be provided a report, and that report only goes to the GPs. It doesn't go to anyone else, unless it's a self-insured and the patient has consented. Then obviously, because the self-insured employers pay for the report, they get a copy of it as well. And I think if you're really in doubt, referring on to an occupational physician and we do this day in, day out. So we're quite comfortable with running case conferences or dealing with difficult employers or difficult claims managers, or any sort of complexity, I guess, that comes with return to work claims. So again, this booklet's actually at the back, but you can actually find it online for anyone who's actually not here today. This gives you an overview of everything you really need to do if you want to do, if you're actually dealing with any patients under the return to work scheme. I've included here some additional resources. AFP or the Australian Family Practice website, they actually have a great article on how to write a medical legal report, as does RACGP. And I think all the MDO websites also, so that's Medical Legal Defense Organizations, all their websites do actually have some guidelines around how to write good medical reports. Any questions? And anyone from online, any questions?
Questions from anyone online, but if those online, if you'd like to, you do have any questions for either Zen or Tracy, please start typing them in. And what I'll do is I will stop the screen share and we can invite Tracy back up as well and have a little opportunity for any final burning questions or anything from anyone. So if there are any questions, I'll pop up there. So those online, if you do have any questions, please type them in and we'll be able to respond to them. Those in the room, does anyone have any questions? Comments? Yes, yeah, I'll just come around 1 second.
Sometimes, what the patient says and what the medical record from what we get from GP, or if you go to, happen to see, like people who play sports despite, their injury claim. What is our legal obligation? Just, just curious.
Sorry, your legal obligation as a treating GP?
Let's say, the patient has injury and then, you or your colleague was involved. And then, one day you see them, contact sports, or like, when you get the GP report, they had a lot of, similar injury in the past, but, on your consultation, they said they didn't have any injury.
I think what you're asking is how much are you legally obliged to disclose if you've observed or ascertained somehow that your patient isn't necessarily telling you the full story? Is that the question?
Yeah.
Yeah. Well, I'm a great believer in honesty is the best policy. I'm not sure that's necessarily your legal obligation because, I mean, I guess if you're asked for a report, then you should put in your report what your opinion is and what your observations are. And I mean, I see plenty of times doctors say, well, the worker told me they didn't have any previous injury. And then we find medical records or other information that shows quite clearly they have. But if you don't know about it, well, then you obviously can't comment on it. But I think I'm not sure. I must admit, I would say you should disclose it. Your patient probably would not be happy about that and they probably go and see another doctor. But, you know, doctor shopping, unfortunately, isn't something that we can stop. But I mean, if you're aware of something that you believe contradicts what your patient is telling you and you are asked about it, then you should disclose it. I'm not sure if I've answered your question. Yeah.
Do you have anything to add to that, Zen?
Well, I totally agree with Tracy with that honesty is the best policy because I've done a couple of IMEs and I feel like eventually sometimes the truth comes out when they summon the medical data or the clinical notes from past history if they've actually got previous injuries that they haven't disclosed. It ultimately comes to surface and it may not impact their claim determination, but you know, it eventually comes.
And potentially does impact either on claim determination or ongoing entitlements. So, yeah, I think just disclosure, if you're aware of something, then disclose it if you're asked.
Now, I do have a couple questions there. Oh, sorry. Was there something else there?
Sorry. Was there something else? Sorry. No? Oh,
No.
okay.
Okay. So we'll go to the questions online. So Alwyn has a question. I'll read it out in case you can't see it. So the common scenario, patient does not want to return to work because of trauma, workplace, bullying or manager singling them out, etc. From a legal standpoint, must they return to work to the same employer? Can we request an alternative workplace? May not be an entirely legal question, but I thought I might ask.
No, it's both a legal and a medical question. Obviously, if you believe that your patient, I'm assuming this is a psychiatric injury claim, that their psychiatric condition would be adversely impacted by a return to work at the pre-injury workplace, then you should say so on your certificate. And I see lots of claims and certificates where doctors certify that the worker is not fit to return to that particular workplace because of whatever reason it might be. They believe they've been bullied or they've been singled out or they've got a personality clash with their manager. Now, whether or not that's the case, that's not up to you. That's what your patient is telling you. And if you accept what they're telling you and you believe it would be adverse to their health, you should clearly certify that they should not return to that workplace. That then will trigger potentially a process where, for example, the claims agent will look to attempt to return to work to somewhere else other than the pre-injury employment. And we see it a lot in psychiatric injury claims where we get those sorts of certificates. Now, that does have some legal consequences, which you don't have to worry about too much because it's a little complicated. But from a health and safety perspective, if you genuinely believe that a return to work to that particular workplace would adversely affect your patient's health further, then you should say so. And then really it's up to the claims agent or the self-insured employer if it's the self-insured employer. I mean, some self-insured employers have more than one work site. So it might be they can't return to the North Adelaide site, but they could go, you know, to a site close to home. I mean, there's all those sorts of possibilities. That's the process where return to work comes in terms of trying to rehabilitate someone back to an alternative workplace. And the same can apply to physical injuries as well. I mean, there are some workplaces that cannot accommodate the restrictions that you've got on the certificate for various reasons. They just don't have that work available, or they're not big enough to accommodate someone long term. And in that situation, the claims agent may well look at return to work to an alternative workplace. And that can happen often. Zen, would you agree?
Yeah, I think from a medical point of view as well, the sooner you make that call, if you feel like they really can't go back to work, and you don't see any future, obviously there's other avenues such as getting a mediator involved, and that's, you know, an independent third party person to sort of sort things out. And if that fails and you really feel like they can't go back to work, I don't see any reason why you shouldn't be putting that in the work capacity certificate. But the sooner you do that as well, the better for the patient, because it does take time to, you know, source a new employment. And with the limited time frame that we have, the sooner the better.
And just on that point, not that it happens all the time or sometimes is not successful, but, you know, possibly is mediation an option that might assist a return to work to the pre-injury employment. If that's something that you think is worthwhile, often that is supported by both Return to Work SA and self-insured employers, because as Zen quite rightly pointed out in her presentation, the longer someone stays off work, the less likely it is that they're getting back to work, either with that pre-injury employer or someone else. So that might be an option to also consider. I mean, obviously not in every case, but sometimes it can be an option that works very well. On to the next one.
Great. We've got another couple of questions from online. So William's commenting that often patients attend with the supervisors from their work during consultations. Is that okay? He feels it compromises the consultation.
From my perspective, I think it's up to the doctor. I mean, obviously the supervisors are probably looking to try and get their employee back to work as quickly as possible. I have seen situations where doctors will want to see the worker first, and then might then have the supervisor in after that. Or if the worker objects, I think the worker's entitled to object. Zen, I'll hand over to you because you're the actual doctor in the room.
Well, I typically like to see my patients first, and then after the full consult, that's when I'll bring them in to actually discuss about the work situation and the work capacity and certification.
Yeah, and I think that's appropriate, to have the consult with your patient on their own, and then if necessary, the supervisor after that, which is usually about return to work more, and that's what it should be about.
Similarly, I think with case conferences as well, I tend to like to see the patient shortly before, even if it's a quick 5-10 minute consult, just to see and debrief and make sure we're both on the same page before we actually bring in everyone else.
Wonderful. Now Shilpa Online's asking, so patients lost follow-up after the patient referred to a specialist, surgery was done and they don't return, but you get a letter asking to certify MMI after a long time. How do you respond?
I generally contact the claims manager, get them to say, firstly, you're no longer the treating doctor, and maybe they have a different treating doctor. Or if they don't, then having the patient come back to see you for a review before you actually do a certification of MMI, because I wouldn't sign my name to any paper that I'm not confident, you know, that won't hold up in court.
That's exactly what I would have said. Always see, if you haven't seen the patient for a long time and you're being asked this question, make a time to see the patient. If the patient won't come and see you, then you just have to respond that, in your opinion, you can't answer the question because you haven't seen them for whatever reason for that period of time. So yeah, and then it will be up to somebody else to provide that certificate. For example, I mean, the surgeon might also get asked if they've had surgery whether MMI has been reached. So
And I should just added also, so most of the time when patients are asked to go back to modified duties, the common response is that they don't have any such duties on site. So what's the best way to respond to this? And actually, she says that it's entirely up to the employer to find a suitable job.
Well, I think the important thing to know is that you're the doctor. It's not really your job to determine whether or not the employer actually has work for them. So my general response is that my job is really to provide the certification. I'm certifying what you can do rather than a specific job. So I wouldn't put specific roles in the work capacity certificate unless I've already discussed that specific role with the rehab coordinator or the return to work person. And I would leave it as a certification of capacity. So what to avoid and what to actually do.
Wonderful.
yeah, I think that's right. I mean, I wasn't quite sure whether it was the worker telling you that there weren't suitable duties or the employer. I mean, if the employer is saying that, well, you have to take that at face value, and it's probably up to the claims agent to sort that out with the employer. If the worker is telling you that there are no suitable duties, I wouldn't necessarily either accept that at face value, because they may not actually know what the suitable duties are that may be available, and that might result in you wanting or needing to confer further with either the case manager or the employer themselves, because I have seen plenty of times where doctors have certified total incapacity because I'm told there are no suitable duties. Well, who were you told by? I mean, your job is, as Zen said, to certify capacity or incapacity. It's up to the employer to then try and accommodate that if they can. And you will find a lot of employers are more than happy to do so. I mean, not everyone, you know, there are good ones and bad ones out there, like in any work. So I think don't just take it at face value.
Wonderful. Now, there's no further questions online. Does anyone in the room have any final questions? Those online, feel free to type any remaining questions you have. Just give it another 10 or so more seconds. No. Looks like nothing further is coming through from online. So with that, I'd like to formally close tonight's education session. Thank you to Tracy and come to this mic now. Thank you to Tracy and Zen for your wonderful presentations and addressing all the questions tonight. So with that, thank you. Enjoy the rest of your evenings. Those on online, the evaluation survey will pop up on screen when you exit Zoom, and those in the room, you've got the evaluations on your table. So please do take the time to complete them, as your feedback is really valuable. All right. Thank you. Have a good evening.